All right, hi, welcome back. Attorney Steve Vondran here. Welcome back to another exciting episode of Vondran Legal Hour. Okay, so this is general legal information only and not legal advice, but we are talking about Scenes-A-Faire. Scenes-A-Faire. This is one of those weird little doctrines in copyright law. I thought I'd share with you kind of what I know about it, and it's real interesting, actually. So when you get into the area of somebody accusing you of copyright infringement, let's say it's a photo, could be a photograph, and could be something like you're taking a photo of a skyline or a bottle. Who knows? Could be a lot of different things. But say you're being accused of infringement. One affirmative defense that can be raised is what's known as Scenes-A-Faire. Scenes-A-Faire. And this is actually a French phrase. I mean, in so many terms in law are Latin phrases, but this is a French phrase which essentially means that which must be done. Scenes-A-Faire, that which must be done. Okay, so what is this talking about? Essentially, this is talking about not protecting common themes, common ideas, common concepts in the world of copyright law. That means, like books or software or videos, common things not being protected, okay? And, I've got some examples here for you. I guess the main case that's on my radar here, it's called Aachen versus Sky Spirits, Inc. Now, if any of you like a good cocktail, or you've been on an airplane, I see they sell it lots on airplanes, is the Sky Vodka. So let's talk about this case real quick. This comes down from the Ninth Circuit. That's your circuit that's going to cover California, Arizona, Utah, Washington, Oregon, Montana, Idaho, all these western states, okay? So this case was dealing with a commercial photographer, Joshua S. Hotskin, and he had done some photos for Sky Vodka. And later on, after he had done work for them, Sky hired their own two photographers to take similar photos of the Sky Vodka bottle. Now, when Joshua Aachen found out, the plaintiff, he said, "What the heck? This is substantially similar. That's the test for copyright infringement, and so this is an infringement. That's almost substantially similar to what I produced, and this is infringement." So the defendant answered, Sky Vodka said, no, this is not, maybe substantially similar, but it's not virtually identical. And when you get into an area where you're just using something, there's no other way to express an idea. Like, how do you take a picture of a bottle? There's only so many ways you can do it. Sky Vodka said, no, we're going to answer with the affirmative defense of Scenes-A-Faire. And so that's what happened in that case. And the court said that's true, although substantial similarity may be a test in a common infringement case, like software infringement, for example, or video infringement. The court says where you have certain commonplace ideas, they can't be protected. You can't give a monopoly to certain common ways to express an idea, common themes, those kinds of things. So really what the court is saying is the originality is really low. In copyright law, we like to protect, high levels of originality. And what the court's really saying is if there's really only one way to express something, like you take a picture of a bottle, that's really not all that original. Although the copyright threshold for originality is really low to get copyright protection, it's really low. The court says, when you have a Scenes-A-Faire type of issue, type of element, the test should really be whether it's virtually identical. In other words, almost, verbatim copy. So here the court said, no, they use different shadows, different angles, but this is Scenes-A-Faire. And a similar concept would be like merger. This is another defense where the idea and the expression merge. It's a separate defense, similar in nature, but it's a separate defense. And so that's kind of what it is. And so the Scenes-A-Faire is essentially treated as an idea, and you don't get copyright protection on it. It's an affirmative defense. So some examples from different genres. You might have book characters, generic characters, cops and robbers. I mean, you're not going to be able to protect those. The drunk and the prostitute, in the murder mystery or the spy novels that have the Swiss bank account or the femme fatale, electronics and gadgets and things like that. Those are just some Scenes-A-Faire things that are probably not going to get a lot of protection, even though they may be in a book or video or whatnot. But more protectable are going to be more specific items, more things that are completely unique. So those are what you're looking for when creating characters, okay? Standard themes, probably not going to get the level of protection. Now, it's important to note that this is important because in the Constitution of the United States, it talks about copyright law and why we have it. Really, why we have copyright law is to promote the progress of science and the useful arts. So, if we're allowing copyright protection for things that are common to a particular topic, it may be a skyline of a city, New York or Chicago, Los Angeles, San Francisco, those kinds of things. Or other things like Microsoft had a case with Apple computers about graphical user interfaces. I mean, there's got to be some kind of interface. So these are the kinds of things where if you're a defendant in a case and you say, geez, why are they wanting thousands of dollars for this photo? You might want to look into the Scenes-A-Faire doctrine and see if you might have a leg to stand on, okay? Scenes-A-Faire in merger is another one to take a look at. So I just wanted to touch base with you. This, I think, is often overlooked. And I just wanted to discuss the general concept with you. You need to do some research in your area. And when it comes to the photos or videos or software that may be at issue, comic books. But that's a general overview. Attorney Steve here. I hope you enjoyed the video and the podcast here. And if you liked it, give us a thumbs up, a follow, and don't be afraid. You can share this on your social media networks. Alrighty, I got to run. Lots of work left to do tonight. Appreciate it. Thanks a lot, and we'll be back.